This week on Inside Olympia, how are political polarization, declining trust in institutions, and artificial intelligence affecting the courts? What challenges do our courts face in providing access to justice? On the program for the full hour this week, Washington Supreme Court Chief Justice Debra Stevens.
From the TVW studio, it's Inside Olympia with host Austin Jenkins.
And welcome to Inside Olympia. The federal courts are in the news a lot these days as states and various groups challenge the policies of the Trump administration. But what about state courts? How are they weathering this polarized political climate? How are they coping with declining trust in institutions? What challenges do they face in terms of funding, technological changes like artificial intelligence, and serving all citizens? Joining me now, and for the full hour this week, is Chief Justice of the Washington State Supreme Court, Debra Stevens. Welcome to the program.
Thank you, Austin.
Nice to see you.
Happy to be here.
We need to acknowledge the fact that you are the Chief Justice for the second time. If I recall correctly, you were first appointed Chief Justice, then you ran for Chief Justice. Now you've run a second time, and you are the Chief. But walk us through sort of how this came about,
Sure.
Why you ran again.
There's a provision in the Constitution that allows the members of the court to select the Chief Justice, and that's typically every 4 years. So I was just elected by my colleagues to be the Chief Justice for the coming 4 years. What happened back in 2019 is that then Chief Justice Mary Fairhurst was stepping down from the court a year before the end of her term as Chief Justice, and I was elected at that time to fill the remainder of that term. And then, of course, there was the election the next cycle, and that's when Chief Justice Gonzalez was elected. And he's still on the court. He was just reelected by the people to a 6-year term and is still a member of the court.
What did you run for Chief Justice? What was your sort of platform? What was your pitch to your colleagues? How are you trying to organize this term and prioritize the work of the Chief Justice?
Yeah. Well, first, let me just clarify that it's not like there's a platform. I don't see it that way, at least. I see the rotation in the role of the Chief Justice as really healthy for a collegial body. It's a lot of work. It's a lot of administrative work, and the chief is the spokesperson for the branch, but also really a mediator of a lot of conversations within the entire branch. So I think it's healthy that everyone on the court stay engaged and that we have in mind succession planning and keeping a rotation. So I will say unequivocally, I do not intend to ever seek to run for a second term as Chief Justice. I really think the turnover is healthy. But what were my priorities? I think what I learned in being Chief Justice when COVID took over all things was the importance of building strong communication networks and having collaborative relationships with the leadership, the court leadership across the branch. And I have a lot of energy for that, and the relationships. That's one of the priorities I have, is to really see if we can work better, because we're not a unified court system, and most of our courts are at the local level, but we can really support the work and better serve the people of Washington and increase, the access, the ability of ordinary folks to access the courts. So that's
sort of, while it's not unified, you're looking at this and saying we should still be cohesive. Absolutely.
And we do have, a structure for a system. So that's one of my priorities, is to really help strengthen that network, because a person's experience of justice in Washington shouldn't depend on where you are. No justice by geography, as we say. So the more we communicate and really work through best practices and open understanding of how the challenges may be quite different in Asotin County versus King County. So better understanding how we can effectively deliver justice. So that was a piece of what I wanted to accomplish.
Because I think people are also curious about how the court works behind the scenes. What is the role of the Chief Justice as cases are being considered, decisions are being prepared? what's the role?
Yeah, good question. It differs in every state, and the way we do it in Washington differs a fair amount from what I understand is the process in the U.S. Supreme Court. I like to say that the Chief Justice really has no power. I mean, truly just the organizer of a collegial body. So as chief, I don't have the authority to decide who gets a riding assignment or to distribute the cases. What we do in our court is once we determine which cases we will hear on the merits, so we have a process for that, and the Chief Justice does sit on both departments of the court that hear those petitions for review. But once we've decided what cases we'll hear and we schedule them out for the term, we literally draw names out of a hat, like the Harry Potter sorting hat, and schedule the cases so that we pre-assign an internal bench memo, and each chambers has responsibility for several of those a term. And then the chief really at conference helps organize the discussion, make sure everyone gets to be heard, keep things flowing along, decide when it looks like we've had enough discussion that we're ready to have a vote, and then report out the results and help keep track of the work as it's moving through.
And what do you think are the qualities of a good Chief Justice in terms of making sure that internally the court is working well and cohesively, even if there's going to be differences of opinions and different personalities? And again, kind of what are you hoping to bring to the job?
Well, let me answer that by saying I think each person who occupies the role of Chief Justice has to do it according, to their own personality. And so I don't know that I think there is a single set of good qualities. I think you have to have a healthy appetite for discussion and for collaboration. And that for me, that's more important than feeling like I'm always the first to be heard, And sometimes I think as a justice, that's a big adjustment. We have views and we want to express our opinion. But I think my first role is to really facilitate conversation. And beyond that, I think it's just, a desire to lean into the administrative work of running good government.
Yeah. So just lastly on that point, how do you gauge the success of the court? And, should the court be hearing more cases, fewer cases? Should you be getting opinions out more quickly? Do you have any thoughts on just sort of the current level of service and how you'd like to see it evolve over the next 4 years? And when I say service, I mean to the people.
Yeah, absolutely. And I think first and foremost, every justice sees this as a role of service, that it really is who are we as a state as defined through the rule of law interpreted in the state. So one marker of success, I think, is the level of debate we have, even about the cases we're going to hear and where we're seeing issues that are unresolved, that need to be addressed by the highest court. Because people should remember, we're not the court of first appeal. Since 1969, Washington has had an intermediate Court of Appeals, and that's where most appeals are resolved and finished. So we take cases only by discretion when there's a broad issue to decide. I don't think taking more cases is a measure of success. To some extent, it can have a negative impact. I think sometimes if a court is more strategic about the issues that need to be decided and leaves some space, for variations on a theme, so to speak, I think that can be better. So I think that's one measure of success. Can I comment on one other thing that your question didn't really embrace? And it's not known by a lot of people, but the majority of the work, of the day-to-day work of a Supreme Court is not deciding cases. It's running the judicial branch of government and the legal system. So we are responsible for overseeing the admission to practice and the discipline and ethical standards enforcement for lawyers. We also have a role in court rules, which are the procedural rules by which folks access the courts and by which cases are litigated. And we do a lot of work just to improve the legal system. How
would you, that's a really interesting point, what percentage of the job of a Supreme Court justice then is deciding cases, which I think most people think must be
Right.
80, 90% of this, versus this sort of more administrative
I think a
oversight
safe
role.
estimate, in my experience, has been about 50-50. And for
Interesting.
chief, a little more than 50% on the administrative side. Because some of the most important work we do that improves the experience of justice for Washingtonians is improving the legal system. You know, addressing issues of racism and bias in the system, looking at, you know, in our own house at the way we've always done things and recognizing that the burden of doing those things doesn't fall equally across communities. We need to address those issues. Sometimes that's procedure changes, sometimes it's through court education, but we do a lot of work in that space as well.
I want to ask you a question about the ongoing, I believe it's ongoing, rehabilitation of the Temple of Justice. You're not currently in the building, or are you back
We are
now?
in the building.
You're back.
Yeah, and what was undertaken was, it took us out of the building for about 2.5 years, but it was a complete overhaul of a very antiquated HVAC system. So during COVID, it became increasingly obvious that we just had an inadequate system that wasn't meeting our needs and probably wasn't providing the best air quality. So in order to do an HVAC renovation on such a beautiful historic building, and you know, the Temple of Justice is the oldest building of the Capitol Group. It was, I think the first event there was held was a governor's ball in 1912. So it's a very old building. So in order to do that work, you know, they have to take marble off the walls and break into, you know, some historic spaces.
Right. So you all moved out.
We all moved
They
out.
rehabbed, and now you're back in. And
Yeah.
Can you tell a difference? Does the air,
Oh,
does the air smell
several
better?
things are, well, we're still in an adjustment period, figuring out how to move forced air through a very large and volume,
Right.
large building. So it's, I wouldn't say that's perfect
Right.
yet. The biggest thing we notice is part of the rehab was updating all of the light fixtures to be energy efficient. And so the lighting is so much better, and you can actually appreciate the beauty of the architecture better than you could before.
Before we go into a deeper dive on a lot of these issues that you've already telegraphed for us, I do want to note that just in the last month, Washington State lost former Secretary of State Ralph Monroe, former House Speaker Frank Chopp, and also former Supreme Court Justice, longtime Supreme Court Justice Susan Owens, who I did not realize had spent much of her judicial career prior to the court in rural Clallam County. And one of the decisions she was, I suppose, perhaps best known for, or that is associated with her, is the very split decision back in 2018 in Washington State to end life without parole for juvenile offenders. You said of Justice Owens and her 44-year judicial career, by the way, she died March 28th at the age of 75. You said of her passing, or at the time of her passing, Justice Owens was a true, original, and a good friend. Though she had been in declining health recently, she never lost her wit, her humor, and her strong sense of justice. The world will not be the same without her. But since I have you here, I'd like to give you the chance to offer a few more words about her legacy and who she was.
Yeah, thank you. Susan Owens was one of the first people to greet me when I became a justice, and she did it in such a witty way that, you know, like, buckle up.
You don't know what you signed
I
up
think
for,
she
huh?
said, yeah, you're in the big leagues now. She was a big baseball fan.
Oh, yeah, that's right.
But even before I joined the court, when she joined the court, which was in 2000, I was a practicing lawyer, and had a chance to meet her when she came and visited Gonzaga, where I was taught as an adjunct. And I was so struck by her unique combination of this. She's a very folksy, easy to know, open person, and also just had a razor sharp intellect. She was very well read, including the National Enquirer.
Is that right?
But I mean, just a voracious reader. She hailed from North Carolina, grew up in Kinston, small town in North Carolina, and came to Washington with her then husband, who was a minor league ball player, but they wanted to live in a rural community. He was from Oregon, but they moved out to Forks.
Wow.
So she loved it out there. I mean, she cooked on a wood stove, in the 80s, just because she thought that was cool, and was a part-time district court judge, first woman in that role, I think, in that county, but also a part-time tribal court judge for 2 tribes on the peninsula. So when she ran for the Supreme Court in the year 2000, it was a big deal for small and rural courts and for the limited jurisdiction courts. She had moved into the leadership of their statewide organization and was a really strong voice for understanding the important role of small and rural courts in people's lives. And, she was a passionate advocate for addressing domestic violence and the role that courts play in that.
Yeah, and she became an expert on that, I think, went around the country speaking
she
about
spoke,
and educating.
Right, did a lot of court education to just help judges better handle those very challenging cases. So she was a force to be reckoned with. And, serving with her for many years, as was mentioned in my comments, we became, good friends as well as colleagues. And I was just very sad.
Yeah. Was she visiting? I think she was visiting family in California when she passed away.
Right. Yeah, she was visiting her son and his family, and she spent a lot of time with her son and daughter and her grandkids.
Okay. So I'm going to ask you about your state of the judiciary address to the legislature recently, because that creates, I think, a framework for a lot of the issues that are top of mind for you and for the court and the courts, especially in these times. But before I do that, I want to ask you about something I alluded to at the beginning, which is just the fact that we are kind of in such polarized times. And right now, the federal courts are being pulled in a very big way into adjudicating, if you will, the Trump administration policies. And I'm just curious, we're also in kind of an era of very low trust in institutions. And I'm wondering what's sort of on your mind from your perspective as you watch this play out and are thinking about the courts as the arbiters and the need to have widespread buy-in and trust on the part of the American populace, but also the sort of danger that courts may lose that. And sort of, whether it's the Supreme Court, district, federal district courts that are making decisions, how do you think the public should be thinking about this?
Yeah, this is a topic very much on my mind, and not just very recently. I think we've been seeing trends for several years about waning public trust and confidence in all institutions of government, including the courts. And a role I play, one of the extrajudicial things I'm involved in is I co-chair a committee for the National Association of Women Judges on judicial independence, and we really track trends and themes, and look at ways we can address, public understanding of what courts do. So I think it's not a brand new issue. Yeah. We've seen some recent examples where there's been just direct pushback, against a judicial ruling. And, I have grave concern that if we have our democracy is a fragile thing. And in every branch of government, the system works when people are willing to use the system to work. So if we don't want to allow each branch to carry out its constitutional responsibility, then I don't know where we turn. So I feel like part of the role of a judge is to be something of an ambassador for what we do. Understanding that the role of courts in our frame of government is to be an equalizer, right? It's a place where everybody can bring a dispute, everybody is equal before the law, and you're entitled to an arbiter of that dispute who doesn't have a stake in the outcome, and that's the real importance of the neutrality. But it's also true that we carry out social functions around crime and punishment. And I think we have to acknowledge that over the course of time, that the impact of that hasn't fallen equally. on all communities. And, there are folks on either side of the political spectrum who've raised questions about the neutrality of courts. So I think as we address the conversation, we have to really look internally and say, how can we have a real conversation that acknowledges that the system hasn't always, and still to this day doesn't work perfectly, but that adherence to the rule of law is still the best thing we have. What's that saying about, democracy is messy, it's a terrible form of government, or it's the worst form of government except for every other form of government. And I think as judges, we need to be out in community talking with folks about what their concerns are and helping and listening and better explaining why we do things the way we do things.
Judges, of course, in this state don't run as partisans. In other states they do, and we just saw record-breaking spending on a Supreme Court race, a state Supreme Court race in Wisconsin, $90 million. Does that kind of spending, does the sort of politicization or partisanship surrounding judicial positions and races concern you?
Oh, it does concern me. I don't think that leaves a good impression, nor should it, because judicial races, one thing we say in our state, we've never had a race like that. They're typically very low information affairs, and it's hard to persuade people when your best campaign pitch is, vote for me and I'll never do anything special for you because I give everybody equal consideration. So it's discouraging when you see those kind of partisan races. People may not know that Washington did initially have, as most states did, partisan voting for judges in the very early days. In fact, it was slate voting. The first 5 justices of the Washington Supreme Court were the Republican slate.
Interesting.
But I think our system, one huge advantage of the nonpartisan approach is, first of all, it's open. Anyone who qualifies can run for judge. And you have to, distinguish yourself based on your experience and your record. And I suppose people also look at, the support that you have in the legal community and beyond. But it's not, I'm of this party or that party. I think that's really important to the integrity of the courts.
Do you have concern that we're on the verge of a constitutional crisis in this country? Or how would you define that? What would you be watching for?
Yeah, I definitely don't think we're anywhere near that in Washington. I think as messy as things can be and as loud as disagreements can be, I think we have a pretty functioning system in the state of Washington. As you hear more about, direct challenges to the authority of another branch, I think that it does concern me because, as I said, what makes our system of government work is adherence to our system of government. And when anyone starts testing the limits of the authority of their own branch or another branch, that's of great concern. And I think that's why people are looking to the courts, because under our constitutional system, federal and state, the courts are the arbiters of what does the Constitution mean and what do the laws mean? And those decisions, constitutionally command respect.
I want to go back to a theme you've touched on a couple of times and alluded to just a moment ago when it comes to fair access to all in terms of the courts, but also the way that courts decide. I mean, people may be looking at the courts and saying, oh, is that a liberal justice or a conservative justice? I think you were saying that maybe a different frame would be have the courts been fair to all people. And historically, how have the courts contributed to marginalizing people? And what's interesting is we're in an era right now of a tremendous national backlash against diversity, equity, and inclusion initiatives. This court, it seems, at least since 2020, has been leaning into that, and it doesn't appear that there's any sign of letting up. If I look at the comments you made at your State of the Judiciary speech about what does justice look like in public? Is the court living up to you quoted Cornel West? Justice is what love looks like in public. Mm-hmm. How how would you describe your thinking and the court's thinking in terms of continuing down this path of evaluating past injustices, trying to make sure the courts are fair, especially in this national climate where there seems to be a retrenchment?
Yeah, I think the first thing to know is that the Supreme Court of Washington is, uniformly committed to, making real the promise of equal justice before the law. And what you saw we issued a letter in June of 2020 that
This
really
was following the murder of George Floyd.
Right. And, I think times of crisis really provide an opportunity to look within and ask, are we living up to the promise that the lofty words, of the Constitution make? And I think what that letter demonstrates, because it gives some examples as well, is that you can look at legal doctrines, at the way cases were decided. You can even look at how court rules require certain procedures, and identify that they're not neutral. They're not without bias, because they presuppose a certain norm of behavior, or maybe a certain economic status, or ability to participate in a proceeding that isn't equally shared. So I think some of the work we're trying to elevate is recognizing that the way we've always done things isn't necessarily the neutral, and everything else is now a DEI effort that's intended to put a thumb on the scale. You've got to go back and look at the scale. And just because something is normal doesn't mean it was ever neutral. And so what we're trying to do is, really examine our processes to create some equitable access to the justice that we want to uniformly deliver. And you see that in large ways and small ways. And one of the small ways might simply be courts better looking at how people can file, when they must come to court, court hours, jury service. We have fought for years, from well before 2020, to look at increasing juror pay to make it more possible for more folks to participate in jury service. And
It's still $10 a day.
yeah, but we're doing a pilot project. We did get funding to run a project in Pierce County and are collecting data, and the early data shows it makes a big difference.
And that's, did they boost it to $100 a day? as part of this
$100 a
pilot?
day. Yeah, so still not up to, a full day's work, but a fair amount by today's
And the early
standards.
indications are that it's creating a more diverse jury pool?
Absolutely. People who were not able to serve,
Right.
have the ability to serve.
Let's take a quick break. When we come back, I want to talk about more of the examples of sort of steps that have been taken already and sort of what's in the future in terms of equal access to justice. So let's take a quick break. When we return, we continue our interview with Chief Justice Debra Stevens. Back after this.
There's been losses every year since the early 1920s. The shoreline itself was almost 2 miles further out there. Year after year, more homes would fall in the water. We have nothing to lose.
And welcome back to Inside Olympia. Joining me once again is Washington State Supreme Court Chief Justice Debra Stevens. And I want to pick up where we left off, asking about if you sort of take 2020 as a starting point, and I know you said that wasn't really the beginning, but it was a key moment. And going forward to today in 2025, what are a couple of other examples you could give of ways that you feel like the court has leaned into this effort to address past inequities and increase access? And what are some examples of things you'd like to yet do maybe in the next 4 years as Chief Justice?
Mm-hmm. Well, let me roll way back to just celebrate that Washington was the first state Supreme Court to commission a group to really look at racial bias and inequity issues, and created a Minority and Justice Commission in the early 90s, first of its kind. And shortly thereafter
And
created...
let me just note that there's a Minority and Justice Commission, there's a Gender and Justice Commission, and a Disability Justice Task Force in this state.
As well, there's an Interpreter and Language Access Commission, and we also have a Commission on Children in Foster Care, dealing with vulnerable children and youth. So these commissions really help convene groups to talk about what the challenges are and how the justice system can be improved to address these challenges. And through the commissions over the years, so many good initiatives have been forwarded through court rules or for judicial education or, to the extent that we determine our own procedures and policies within the branch, looking at that. But also to advocate for changes in statute to systems that affect the justice system. So, for example, all the work on legal financial obligations. A lot of work was done in a task force that I was part of when I was a member of the Minority and Justice Commission, really showing the evidence of the impact of fines and fees and the need to reform that. And a lot of great, programs continue to move forward that I think are serving public safety and, making justice more equitable.
And we've talked about jury selection. Bail has been another area, I think, of scrutiny and focus, too.
Absolutely, yeah, on the standards on pretrial release. Another one that's a little, that finds a home in many areas of law that I really want to emphasize comes out of a court rule originally that Washington adopted around jury selection. It's a general rule, 37 is the number, so we call it GR 37. But it had to do with a challenge to someone's attempt to remove a potential juror from sitting on a panel, and was that removal sought on the basis of race or other bias? And the
Would
U.S.
these be the peremptory
peremptory
challenges?
Challenges. So there's a series of, anybody can be removed if the judge agrees that the person can't be fair in the case. They know one of the parties, they've had a similar incident. That's called a for-cause challenge. But there's a long-standing series of peremptory challenges, which really are just those extras that let the parties kind of,
I have an uneasy feeling. I don't think we want that person on the jury.
Right. The judge wouldn't strike him for cause, but I don't. Or maybe, so they're peremptory challenges. They don't need a reason. But based on some constitutional law that goes back to a U.S. Supreme Court case, Batson versus Kentucky, a body of law developed that if a person could establish that attempt to remove a juror was based on their race, then if the court found that to be the case, you could deny the challenge. Well, the reality is, in the history of Batson, nobody ever proved that up. It's very difficult to prove intentional racism in the exercise of a peremptory, and in particular because the standard just required, usually it was the prosecution in a criminal case, the common scenario, trying to remove a black juror when there was a black defendant, and the standard simply required a race-neutral reason. So it wasn't a very effective standard. And Washington adopted a court rule that was promoted by a group of folks in the legal community and beyond that changed the standard in two really important ways. One is it said in deciding, it said first that it was enough that race was a reason, a motivating factor, for the removal. And in asking that question, the court had to apply the lens of a reasonable person aware of implicit bias and its effect on our decision-making. So that informed lens. And then there are other procedural changes in the rules. Certain things are presumptively not race-neutral reasons. So, for example, if a person says they don't have a warm, fuzzy feeling about law enforcement, or they've had negative interactions, that's presumptively not race-neutral because of the evidence of, disparate impact of those encounters. So that rule was adopted, now I'm forgetting which year, a while ago, and is settling in, and practice around that and cases around that are settling in. But the lens of that rule, which is to look at the reasonable person as one who is aware of systemic racism and implicit bias in our system. That lens has been carried forward in a number of contexts that I think are really developing a better understanding of how we apply the law. So as one example, in a typical law enforcement encounter, and the question sometimes in a search and seizure scenario is, would this person feel free to leave? Well, it's got to be a well-informed view of a person aware of these situations, aware of experiences. Would they feel free to leave? And not importing, the judge's own view of, well, would I have felt free to leave? So I think those may seem like subtle examples, but those are really, transformational shifts in how we look at questions that we ask and answer under the law.
So if you think about carrying that forward, and something else the court has done in recent years is take a second look at past decisions, language that was used in some of those decisions, in some respects repudiated some of the terminology that was used by justices previously. So two questions. One is this court kind of actively looking for other opportunities to revisit past decisions with an eye towards bias? And then secondly, do you see opportunities to do something similar to this change in the jury rule, kind of in terms of future changes that might have sort of this trickle-down effect to the lower courts?
Well, I will say the way the court's docket gets built, we really do rely on, the parties, somebody bringing to us a case and identifying a theme. Right. So I don't want anybody to get the impression that the court's out, looking to manufacture cases. And, the reality is you don't have to look very far to find cases that provide an opportunity to re-examine something of longstanding that this has,
Right, this has come up in the context of new cases where it's an opportunity. But maybe in the past the court wouldn't have even considered. That's right. Yeah, so I think the big shift in my time on the court, and I first became a justice in 2008, and so there have been subtle shifts. I mean, I think probably someone who, like Justice Johnson, our senior justice who joined the court, he was elected in 1990, he would talk about the big shift between 1990 and 2008. Just attitudes tend to evolve. But I do think part of our decision-making rubric, if you will, is being aware of, sort of those things that are hiding in plain sight in a case or in the language that's used or in the precedent, and working through those in the course of working through the opinion. So I do think it's a more fully informed lens. And do you anticipate we'll see more examples of that? Absolutely. And I think we're seeing that not just in courts, but, across society, And I have to say, I think there's a big reason for that shouldn't go unacknowledged, which is that more people of color and people from marginalized communities are joining in places of decision-making authority. And, just as, Justice Ruth Bader Ginsburg, once, was asked how many women, was enough, and she said 9, but she also said, women need to be in every room where decisions are being made. Well, people from diverse backgrounds need to be in rooms where decisions are being made, and it changes the conversation. There's actually jury research about this too, that more diverse juries change the deliberation. They consider more issues when everybody's not thinking alike. I know that this court has emphasized and you mentioned in your State of the Judiciary address, you gave examples of therapeutic courts and other ways of reaching people outside of the traditional superior court, for instance. There's the language access services you talked about, restorative justice initiatives. There's the jury pay reform. There's a pretrial pathways program in Pierce County. There's the ongoing Blake decision relief for people's simple drug possession sentences are being overturned, revisited, and vacated, and money being refunded, I guess, fines that were paid. All of these examples, and then there's efforts to get your court out on the road, rather than making people come to you, you go to them. But as you think about sort of these, the array of ways in which the courts are trying to become more accessible, more equitable, more available, and again, you think about your term as Chief Justice, where are you headed?
Yeah, I find this work, it's exciting to see when it makes a difference. And I can say having the chance to go to what we call a therapeutic court or a problem-solving court. So these are like...
Or veterans courts, another example.
Yeah, veterans courts, DUI courts, drug courts.
They're specialty courts.
And they require people who participate in the program to engage in, over long term in services to help address the underlying, root circumstances that, led to the criminal behavior. And boy, when you go in and you see after, a couple years, somebody who's come so far from where they were, and they have a really open dialogue with the judge who's been checking in with them regularly over the course of that time, and they graduate. I mean, that's when you see that this is how, courts can really affect people's lives. And why would we ever do it differently? I think we should all be very concerned with, the effect that mental health crisis and addiction has on our society. And the courts are oftentimes the first place people get connected with any help at all, especially given, the challenges with public health and access to public health. The courts are often the first chance for someone to get intervention. And if it's not the first, it's sometimes the most successful. So having those kind of programs, I think, really moves the needle on both public safety and individual accountability, as well as, making sure when someone finishes that term, they're on the way to something better and not on their way to the next offense that's going to bring them back.
Another topic that is national in nature, there's headlines across the country about this, and including in Washington, is the state of the public defense system, which is also obviously key to access to justice. I know that currently before the Supreme Court is a question about whether to reduce public defense caseloads. The Washington Defenders Association wrote a letter to the Supreme Court saying public defense in Washington is at a tipping point. I think we've heard this before. I know you're limited in how much you can say about this since it's before the court, but what can you say about public defense in Washington State, especially through the lens that we've been discussing, which is access to justice?
Right. Can I start by just asking to zoom out a little bit and consider that constitutionally, when a person's charged with a public offense, a felony offense, they're entitled to a lawyer. And then through a complex of rules and statutes and build-outs of constitutional provisions, other case types too. Yeah. But it's an important part of the integrity of our system that someone facing a loss of their liberty is entitled to a lawyer. So as we look at what we criminalize and what we prioritize, I think it's helpful to consider that as a whole system. And, it's interesting that you mentioned the Blake decision, which invalidated a strict liability drug possession statute that didn't require proof that the person found with drugs
had the intent.
Had them knowingly, yeah.
Right.
So
if you have them on you,
then you were guilty of a felony, so that invalidation.
And it was the Supreme Court that invalidated the law, and now the Office of Administrative Courts is actually administering this.
Well, the legislature created a system, tasked the Administrative Office of the Courts with a Blake refund process and vacation process. And this goes back 40 years. Right. The statute was of long standing. But one of the things I want to highlight is that the legislature then, over a couple of sessions, considered how they would approach drug possession charges, and they have a new set of statutes around that. And one program that the Judicial Branch Office of Public Defense is developing is a model for simple possession prosecutions that looks at everything involved. So it looks at the prosecution costs, the public defense costs, access to services, like addiction services and other community supports.
Can you get treatment?
Right, and community supports, and then also court costs. And I think that's such a smart way to look at how we address public safety and problems, to consider all the costs that go with that. So the reason I wanted to start with that and zooming out is the fact that we have a public defense crisis. It didn't just happen overnight, and it didn't really surprise anyone. And the standards that are being referenced in the rule that's before us date back to a decision in 2012 when I was on the court, and we adopted for the first time in court rule a set of standards for for indigent public defense. So attorneys have to certify that they're within reasonable limits about the number of cases they take and how fully supported that public defense work is. So that dates back to 2012. But the existence of standards of practice around that predate the court rule by a long time, because the Bar Association actually had a statutory authorization to create these standards. And they've done that for years. And there are actually more standards that the Bar Association advances than are in court rule. And I think that's an important context for people to understand, because in many counties, the county defense offices have already adopted the Bar Association standards. So the court rule, whatever happens in court rule might not affect them at all. So that's a little bit of backdrop. But I will say this is a rule that we know is of huge moment. It was developed and proposed to the court over, it took months to develop and stakeholder it, and before it was ever proposed. And the court held 2 public hearings and accepted comments, hundreds of comments. And the proposal is to adopt a whole new set of standards as well as look at the case numbers. Yeah. So there's a lot there. And what the court's engaged in now, in a level of some detail, is a series of work sessions as we're working through all of that. So we haven't made a determination yet. I know obviously other folks are working on different aspects of addressing the issue, but it's still pending in front of the court.
And I trust you cannot telegraph when a decision might be coming. Even if I wanted to, I think what I need to emphasize is that there's a lot involved, and it's a decision that requires careful review. When we look at court rules, it's not like we're just adopting a concept. We're actually looking at a rule that has to be enforceable and capable of interpretation and application. Well, let's hit the lightning round here in the 5 or 6 minutes we have left. What topic you and I have discussed before that I'm very interested to hear you opine a little bit about is artificial intelligence and how that is seeping into the judicial branch, into courts. I know attorneys have gotten in trouble for using ChatGPT to write their briefs and then reference cases that don't exist. Courts have to think about writing rules of the road for this. I imagine there are opportunities for AI to be helpful. Yeah. How are you thinking about this brave new world that's upon us?
Yeah, well, as you and I have discussed, I think a lot about this. I'm part of, I lead a Washington team of judges and court administrators and a court educator who've been receiving some amazing education about data science and AI for the past year and a half, and really helping compile education resources. We've been putting on education programs for court professionals, judges, and court administrators. So I think there's a couple things I'll observe. AI is here in ways that are, because of the way AI operates, and self-learns, it's accelerating so quickly that I think attempts to directly regulate specifics have already proven futile. The approach we've taken in the branch at this juncture around a framework is the Board for Judicial Administration, which is the gathering of all the levels of court and entities. We call it the BJA, adopted a set of principles that will govern how we assess the appropriateness of AI as it comes into courts, maybe as evidence, and also as courts use systems, maybe for front desk assistance or translation or other things that are being considered. And those principles include equity. One grave concern about AI is it's being very commodified. And if you look at the practice of law, only a handful of firms
can afford
to use those tools, which can be really, really helpful. It also is very technology and bandwidth dependent, and not everybody even has access to broadband. So we've got to consider pockets of our state that still would be challenged if that technology became the norm. But besides equity, there's also concerns about compounding bias, because any kind of machine learning takes bad inputs, bad outputs, and it compounds that and deepens biased learning sometimes. Real concerns about data privacy and individual privacy. And I think that's some of what we're starting to see in courts, and see search and seizure challenges too. That's been around for years, I guess, around GPS, cell site position, location of different sorts. But now, we're talking more about face recognition and, enhanced dash cam videos and different things that courts are actively having to look at.
Well, and I would imagine you mentioned evidence before, in this era of generative AI, can you trust the exhibit that's being brought in?
Yeah, and that's so we're doing a
evidence.
program. We're doing programs this year, drilling down on that more, and really fortunate to work with some computer scientists on that, because I think for most of us, we think of AI, it's talking to us, it's creating pictures, but it's data science. So I think what it goes to is a little bit of how, when a piece of evidence is offered, and let's say it's a video and you want to know whether it's a fake, what are you going to have to show? What kind of experts are you going to need? And the concern there is, again, back to cost. All of that can be done, but it's not inexpensive either.
Do we need to worry that Supreme Court justices are going to start using ChatGPT to write their opinions?
No, I can say that a big concern about using ChatGPT or similar tools is the data privacy. And at this juncture, a draft of an opinion is a very confidential thing, so you don't want to run that through ChatGPT.
Right. We are running out of time here, so I want to ask you for a closing thought or two. By the way, cybersecurity has got to be top of mind. You guys did have your website was shut down for a while, and background checks for gun purchases were delayed. Things are back online now, but imagine that was a disruption one would not want to relive.
Though, can I emphasize that back online in record time? Yes, the incursion occurred, but it was stopped quickly.
Was it detected quickly?
It was detected quickly, and then as different, blooms of it happened, they shut those down quickly too. And things were fully restored in about 18 days, which is really remarkable.
At the
given
time,
the
it
size
probably
of the
seems
attack.
like eons. But
right, yeah. We understand the impact on criminal justice systems. You mentioned we were very concerned about people's confidential data, but no data was taken, and the system was fully restored, and that was because of a lot of 24/7 work by some very talented people at the Administrative Office of the Courts.
A final thought as we wrap up here, and as you launch this second, not really a second term, but second time as Chief Justice.
I guess I approach this, and maybe it's just because I'm older, I'm at a different space, maybe some battle scars. I have such incredible optimism for where we can go, and for all of the commitment I see in people around me. For all the concerns, and we're never without deep concerns, I think when we really talk to one another, we exchange our different views, we give the space to assume the best intention, by people we're engaging with. Good things happen, and committed people step up. So I feel a sense of optimism in our justice system, and excitement about the people who want to be a part of that system and a part of solutions.
Okay, I got to stop you there. Chief Justice Debra Stevens, thanks for the conversation.
Thank
Appreciate
you,
it very
Austin.
much. Thank you for watching Inside Olympia. We will see you again next week.